And welcome to this webinar on antitrust and healthcare issues. We're going to go through some very basic antitrust issues and talk about how those relate to healthcare, talk about some potential pitfalls and how to work through those. And we'll do that in the context of discussing some recent developments in antitrust law and how that applies specifically in the healthcare industry. If you have questions throughout, please feel free to send those by the question and answer function on the event center. And the way that we'll respond to those is by email to all participants after the webinar has concluded, so that everybody has the answer and we make sure that we get it right. So with that, we'll go ahead and get started. My name is Corey Talbot. I'm a partner at Holland & Hart. I practice generally in commercial litigation and antitrust specifically. All right, so as I mentioned, we're going to be talking about pretty basic areas of antitrust enforcement and in particular how antitrust plays out in the healthcare arena. Let's start first by talking about who is looking at these issues. First, and this is really most importantly, the Federal Trade Commission is looking at this. The Federal Trade Commission has, in Mergers 4, a group that is designated specifically to address healthcare issues with the antitrust laws. The FTC has made pretty clear over the last several years that they are skeptical that mergers are necessary to provide more affordable care. And they have also been successful in large measure in convincing courts of this too. So the FTC is the primary enforcement agency on healthcare issues. The Department of Justice is also tasked with enforcing antitrust laws. They have the potential to bring criminal actions. This is very rare in the healthcare arena, but the Yates memo, which is a recent memo put out by the DOJ, has reinvigorated this area of law where the Department of Justice has signaled very strongly that it will be pursuing criminal actions against individuals who have been found to violate antitrust laws. And so it does add some more concern to the area and more likelihood that the DOJ could be stepping in on antitrust issues. State attorneys general are also involved. They frequently join in FTC challenges to hospital mergers and other healthcare issues that are raised by the FTC. And then finally, competitors. Your competitors may have concerns about your methods of competing with them and might raise antitrust challenges. Those are often raised as potential issues, but followed through on much more rarely. Antitrust cases tend to be expensive and long-lasting, and most competitors don't like that, and so when they do get involved, it's very frequently, much like state attorneys general, following along with an action that has been brought by the FTC. So what are their goals? The agency's goals in looking at antitrust enforcement is to improve consumer welfare, and they do that by protecting competition. So this is not protecting a particular competitor. If there's an inefficient competitor who is losing business because the other competitor is simply more efficient, provides a better product, that's not a concern for the agency. What the agencies are concerned about is where entities or people are prohibiting competition or restraining or reducing or causing barriers to competition. Those are the issues that they look at. It's competition generally, not the impact on a particular competitor alone. And the reason is that competition generally provides lower prices, better quality, and more output. And this is something where, especially in healthcare mergers, there has been a lot of pushback from the healthcare industry on this, because efficiencies are touted as key benefits of some of the mergers that we're seeing in the healthcare arena. The agencies are very skeptical of claims of efficiency. And I think probably the best way to look at that is through an example. The FTC challenged the merger of two hospitals in Pennsylvania, and this is in the Hershey Pinnacle Hospital merger case that just came out about 2 or 3 weeks ago. And the FTC challenged this merger, arguing that it was anti-competitive. The district court ruled against the FTC, did not allow a preliminary injunction which the FTC had sought, and the FTC appealed. The Third Circuit just issued its opinion, and one of the issues that it addressed in reversing the trial court was the defense that the hospitals had raised that their merger would be very efficient and thus pro-competitive. The Third Circuit dismissed that, and while the FTC tends to be skeptical about the defense of efficiency, courts haven't really acknowledged that that defense even exists. The Third Circuit actually followed the the ruling in the Ninth Circuit previously on the St. Luke's merger, which is much more local to us, expressing skepticism as to whether an efficiency defense really existed at all. It didn't decide that it didn't exist, though. Instead, what it did is it looked at the efficiency argument that the hospitals had made. And the court said, well, if we're going to allow that defense, it has to be merger specific, it has to be verifiable efficiencies, and they can't be speculative. And they can't arise from anti-competitive output, reductions in output. So the efficiencies that the hospitals argued were that they could avoid capital investment in additional beds by the Hershey Hospital, and it would enhance their ability to engage in risk-based contracting. The court rejected both of those. The court first said that avoiding that capital investment in additional beds was ambiguous, and it could actually be anti-competitive because it could be viewed as a reduction in output by not adding additional beds that could be necessary otherwise in the market. The risk-based contracting claims also not merger specific, and so the court found that was not, those efficiencies didn't help the hospitals in that case. And so the takeaway, I think, from cases that have addressed the efficiency defenses, while the agencies may be skeptical, they're the ones that you would need to convince of the efficiencies, because agency staff will consider the efficiency argument. That's been the position of the FTC, that they will consider it. Courts have not yet, though, really been willing to admit or adopt the notion that efficiencies are properly a defense to an antitrust challenge. So instead, courts look to these goals of the agencies that the agencies have generally. Competition provides lower prices, better quality, and more output. So what are the agencies looking at? We're going to talk about some of the different antitrust statutes that agencies typically look at. And first is the Sherman Act. And the Sherman Act prohibits combinations of entities that will restrain trade. And in looking at those transactions, there are a couple of different standards under the Sherman Act. First, there are transactions that are per se automatically unlawful. And a couple examples of these are price fixing. So if you and your competitor simply agree that you're going to charge X amount for a certain service or product, that is price fixing. It is per se unlawful for you to do that. It's a violation of the Sherman Act. So if there's a naked agreement with a competitor to fix prices, it is per se unlawful. Agreements not to compete, the same thing. and let me be clear about the context of this. If you are, for instance, dividing up a geographic location and saying, we'll agree that we will only compete in, say, the north part of this county, you'll only compete in the south part of this county, that's an agreement not to compete that is a per se violation of the Sherman Act. And so those are types of agreements that are per se or automatically unlawful. Other transactions that may provide a restraint on trade are judged by the rule of reason. And the rule of reason basically takes a look at the entire transaction. Sometimes it's given more scrutiny, sometimes less, but the basic notion is if we look at the entire transaction, there may be some anti-competitive parts of the transaction, there may be some pro-competitive parts of the transaction. How does that balance out? Do the pro-competitive aspects of this transaction that may, in some aspects, restrain trade substantially outweigh the anti-competitive aspects of the transaction? And if so, courts will let those go. So that can be good. And again, one big issue with that is that these are time-consuming and expensive things to argue. So again, it's better to address this at the agency level rather than get to court. If a party is able to demonstrate a lack of market power as well, that's another reason for a court to view a transaction favorably under the rule of reason, because it doesn't have a meaningful impact on competition. Okay, we've kind of talked about this a little bit. If the agency uses a rule of reason analysis, it doesn't automatically mean that a transaction is allowed. They simply look at pro-competitive and anti-competitive aspects. The market share is typically the critical consideration, and this is especially the case in the healthcare arena. If you look back over the last decade or two of the FTC's enforcement of antitrust laws in the healthcare arena, what you see is a substantial number of cases the FTC loses turn on the court's rejection of the FTC's argument about what the market is, and in particular what the geographic market is. And let me kind of explain that a little bit. When a court is looking at the market of a transaction and trying to figure out what the relevant market is, it's going to consider what is called a hypothetical monopolist. And the hypothetical monopolist is that the court will assume that some entity or person has a monopoly in a particular market area. And if that person is able to increase prices under this hypothetical situation, the court will then find that is the market area. So the way you would do this, for instance, is you would say, let's imagine there's a town that has 2 hospitals, and there is nearby in a neighboring town 2 other hospitals. And the court would look at whether, if there were, say, a monopoly in one of those towns where the 2 hospitals had the same ownership, could they engage in what is called a small but significant and non-transitory increase in price. In other words, could those hospitals in the one town raise their prices a non-significant amount for the long term, for a longer term, without losing patients to hospitals in the other town? If the answer is yes, then that is a market. That town with those 2 hospitals would be deemed a market. If not, then the market would be something bigger than that, and so the market would be expanded and the hypothetical would be considered again, until you get to the point where a hypothetical monopolist could have a small but significant and non-transitory increase in its pricing. Once that's been established, the smallest area where that can occur is the relevant geographic market. The FTC has really refined its analysis on this and has been able to succeed in cases in using that type of analysis. The way the hospitals have usually countered that is to use what is called the Elzinga-Hogarty model. This is an economic model that hospitals use have used to counter what the FTC is arguing, and what that model measures is patient flow. In other words, are patients going to choose, going back to our hypothetical, to go from one town to the other based on the small but significant and non-transitory increase in price? This model has really been criticized by the FTC and increasingly by courts as not applying very well in the healthcare industry. And I think not surprisingly, this is because the patients aren't the ones making the cost decisions. There's typically a payer, a health plan, that is providing payments for that. The Elzinga-Hogarty model was actually designed to deal with, for example, the beer industry and whether changes in prices in one store would impact consumers' choices to buy beer at one store versus another. And it didn't apply really well to the healthcare industry without considering the actual payers. And so that refinement by the FTC has really helped the FTC to be successful in determining what the market is, what the relevant market is, and thus defining the market share. That critical consideration has allowed the FTC to be very successful in recent years in making antitrust challenges. We've talked about the efficiencies, the value added, and then any proposed restraint on competition must be reasonably necessary to produce the claimed efficiency. It can't be overbroad. So in collaborating or working together, healthcare providers need to be sure that they are not going beyond what is absolutely necessary in restraining trade to be safe from antitrust scrutiny. Okay, moving on, another act that the agencies look at is the Clayton Act. This is a very, very broad act that encompasses some of the conduct we've already talked about. It prohibits acquiring stock or assets that may tend to substantially lessen competition in a line of commerce. So the agencies have a lot of latitude here, and the other component of this that gives them a lot of latitude is there's no time limit. They can challenge, for instance, an acquisition of the stock or assets of a company like a hospital after that deal has closed and gone through. And even though it's really hard to unscramble an egg, the agencies have forced hospitals to do that in the past. Importantly, employment is not an acquisition under the Clayton Act, so acquisition of employees are not considered potential violations of the Clayton Act. And then back to the Sherman Act again, in addition to agreements that tend to restrain trade, the Sherman Act prohibits monopolization and attempts at monopolization that are done by improper means. Courts have taken a pretty conservative view of this provision and limit that to conduct that's predatory or unreasonably exclusionary. And the FTC thinks that the courts are too lax in pushing enforcement under this section of the Clayton Act. That said, the courts haven't shown much of a willingness to change their view based on the FTC's concerns. And then finally, the FTC can enforce antitrust laws through the FTC Act itself, the act that created the FTC. This has really not been an issue, though, that has come up in the healthcare arena or generally at all, really. Okay, so what types of behavior create antitrust risk? Refusals to deal. Refusing to deal with another party is behavior that can cause problems, and this is where two parties have a profitable relationship. One of them cuts off that relationship for the purpose of forcing that competitor out of the market. It's an area that's difficult to prove, but it's also an area where it may be easy to allege that something like that has happened, and so it creates risk. That's tying can also create risk, and tying is where the purchase of one product, for instance, is tied to the purchase of another. And so frequently what will happen is that a seller will sell a product but require the purchaser to purchase not only that product but another product as well that that buyer may not necessarily want. That's another item that can create risk. Bundling is similar, and this is where you buy a product and then you are able to purchase another product for a lower price because you have purchased the first product. And that those are, while they're not necessarily per se illegal, they do create antitrust risk. And then exclusive dealing can create antitrust risk as well, depending on the market and how that's set up. It raises a red flag in some instances, though, if you do have exclusive dealing, so it's worth considering other options or at least being aware of the antitrust risk with respect to any particular exclusive dealing contract you might have. Okay, so that's sort of the general framework that we're going to be talking about today, the antitrust laws. Now let's talk specifically more about healthcare. The agencies have, during this administration, set out what they are most concerned about, and you'll see this list of industries, and healthcare is right at the top. This has been a little frustrating, especially in the healthcare arena, because of the perceived tension between antitrust enforcement in the healthcare arena and the Affordable Care Act and the goals of that act. So why is healthcare targeted? It's not an especially competitive industry. Insurance takes out the direct payment by consumers, and as a result, there's not necessarily the type of competition you typically see in other industries directly related to consumers purchasing services or products. It's also not particularly competitive because of asymmetrical information, and that is that typically one party to this transaction has much more information about the costs, about available services than the other participant in the market. And so those two general issues of insurance and asymmetrical information have led to a situation where the federal agencies feel like they need to be very careful in scrutinizing the industry as a whole. Now, the conflict here arises because you have pressure from the federal agencies in enforcing antitrust laws to be very careful about collaborating with competitors, and consolidation within the healthcare industry is fraught with peril because of the concerns that these agencies have. On the other hand, there's significant pressure and financial pressure, especially under the Affordable Care Act and other health care reforms related to that really make consolidation in the healthcare industry very enticing. As a result of these, though, the agencies have been very, very vigorous in enforcing antitrust laws and have not bought this notion that the healthcare industry should be treated differently because of the Affordable Care Act, and in fact, to the contrary, the agencies think that is that has been the means of creating less competition in violation of the antitrust laws. And so that focus on consolidation has made antitrust enforcement much more important within the healthcare industry. So, healthcare providers, because of the Affordable Care Act, though, are trying to level the playing field with dominant insurers, take advantage of the financial benefits provided by the ACA so that they can reduce expenditures. There are very real financial incentives for parties in the healthcare industry to collaborate and to work together. So the agencies, they do recognize this, and they have provided guidance. There's a state antitrust policy statements that have been put out, and in particular one we're going to talk about is the Statement of Antitrust Enforcement Policy regarding accountable care organizations participating in the Medical Share Savings Program. That policy statement was provided early on under the Affordable Care Act. It provides guidance to affordable care organizations, or ACOs, network of doctors and hospitals that share the responsibility of providing care to a population of Medicare patients so that they can save costs and share in those savings. While that may seem fairly limited, the agencies have been applying these principles beyond that situation. And so it really does provide a broader level of understanding as to what the agency's concerns are. So let's look specifically at some of these tensions between the Affordable Care Act and antitrust laws. The ACA, as we've talked about, does provide financial incentives to ACOs. The upside, if you do it correctly, you're going to lower health care costs. If you don't do it correctly, it raises the specter of antitrust issues. Earlier this late spring, the FTC Commissioner Edith Ramirez said she's very concerned about the rapid rate of consolidation among healthcare providers. And she is concerned that Affordable Care Act initiatives furthered by state laws are often misguided and risk harming consumers. And what that's referring to is a number of state laws in, for instance, West Virginia, where a healthcare provider can go to the state and obtain a certificate of public advantage, and that is essentially a finding by the state that a particular transaction is in the public interest, and accordingly, that healthcare provider would be immune from antitrust risk as a result of that transaction. The FTC, of course, is not bound by state law, but it creates a very difficult position for the federal government to come in and try to challenge a merger, for instance, that has already been approved by the state. Interestingly, another FTC commissioner, Julie Brill, entirely rejected the notion that there's any tension between the ACO program and antitrust enforcement, saying the goals of the ACA and antitrust enforcement are aligned and compatible. And I think there's a very real question as to whether that is right. The Third Circuit in this Hershey, Pennsylvania case that I discussed earlier that just came out a couple of weeks ago talked about this, and what had happened in that case at the trial court was the trial court found that it had to look at the evolving landscape of healthcare, and the climate created by government healthcare policy that virtually, quote, virtually compels institutions to seek alliances such as the hospitals intend here. The Third Circuit rejected that and simply said, opining on the soundness of any legislative policy that may have compelled the hospitals to undertake this merger isn't within our purview. So the Third Circuit and the courts generally have taken that view that whatever pressures have been put on the hospital by legislative policy under the Affordable Care Act really don't play a role in antitrust analysis. And so you have these, you really do, I think, have those competing tensions between the laws where the policy of one law conflicts with the policy of another. And the problem is you just may not be able to get a court to care about that. So the policy statement provides a safe harbor, though, where transactions can avoid antitrust scrutiny. So an ACO that fits within this safe harbor does not present antitrust risk if it meets 3 factors and there are no extraordinary circumstances. The notion of what are extraordinary circumstances is, I think, intentionally vague, because it does allow the agencies to look at transactions, even if they do fall into the safe harbor, to at least verify that there is nothing so out of the ordinary that it would create antitrust risk. Okay, the first factor to fit within the safe harbor is the ACO participants together don't provide more than 30% of a relevant service in any single ACO provider's primary service area. There are exceptions in this for rural providers, and unfortunately it's very difficult to measure and satisfy this factor. And this goes to the notion of how do you define the market. The St. Luke's case a few years back up in Idaho is a good example of this. The battle in that litigation really was over how you define the market and how you define the competitive issues related to that market. So while this is pretty clear guidance on its face, determining what the actual market is can be a bigger fight with the agency. The second factor is that there's no exclusivity involved. No hospital, no ambulatory surgical center participating in the ACO is exclusive to the ACO by contract or in practice. So if you have an agreement that makes clear that the ACO is not exclusive, but in practice it is exclusive, that can take you out of that safe harbor. And so it's important to follow through on that even after the ACO has been formed and found to have fallen within that safe harbor. And the final factor also relates to exclusivity. And this is if the ACO includes a dominant provider, and that's a provider that has more than half of the market share of any service that no other ACO participant provides, the dominant provider doesn't have an exclusive relationship, and the ACO won't restrict any payer's ability to contract with other networks. And this again goes back to the concern that the agencies have, and the FTC in particular has, with the fact that the healthcare industry is different in light of insurance. And so it looks to the payer's ability to contract with other networks. Okay, so if it falls outside the safe harbor, what is the agency looking at? First, the facts and circumstances, and to suspect behavior. So what's suspect behavior? Anti-steering, anti-tiering requirements that may push services to a particular tier in a network, to a particular provider. Those sorts of provisions cause concern for the agencies. Tying services to services from other providers outside the ACO. That's risky behavior. Having exclusive contracts, and I think you saw earlier in looking at those factors, the agencies really are concerned about exclusivity because it tends to restrain competition. Restrictions on information. Again, it's an asymmetrical industry generally when it comes to information, and when parties agree to have additional restrictions, that raises a red flag for the agencies. And finally, price sharing. Price sharing is a really bright red flag when it comes to antitrust laws generally, and so price sharing has to be something that is done very carefully to make sure that it's correct. Broadly speaking, price sharing should be aggregated so that it's not clear which particular party had which particular price. That should be aggregated among a group of parties. And it should also be historical information rather than current information. So if you are, for instance, sharing pricing information from the last month, with your sole competitor, that's a big problem, and the agencies will see that as a big red flag because it promotes price fixing. On the other hand, if you are sharing aggregated price information among half a dozen competitors and the information is a year old, so that you can't tell who had any particular price, and that information may no longer be very relevant to current pricing, that has a much lower antitrust risk, and the agencies won't see much of a concern if you have those sorts of safeguards involved in any price exchange, any exchange of pricing information. A bit of good news here. Under the policy statement, you can get expedited review for ACO formation as long as you're not yet participating in the savings program. This expedited review is really helpful to get things moving along quickly. So how does it work in real life? We're going to go back a few years to a Norman, Oklahoma PHO that shed some light on the agency's view of how this policy statement actually works in real life. So what was happening in Norman is that the PHO included the Norman Regional Hospital, 238 physicians. They've been in operation since the mid-90s using a messenger model, so there's no agreement among the competitors as to how they're pricing, how they're integrated, and so forth. The PHO wanted a clinically integrated model, though, and so they presented this to the FTC, and the FTC analyzed it under the rule of reason. It avoided the per se analysis by pushing for an integrated network, and so providers can be financially integrated or clinically integrated. And if it's financially integrated or clinically integrated and the agreement's reasonably necessary to provide pro-competitive benefits, then it can be okay. The agency will examine that on a balancing scale under the rule of reason, but it's not necessarily per se illegal. Again, this messenger model, there was no agreement between the competitors. So how do you achieve that? Financially integrated networks providers share a significant risk of the financial performance. Clinically integrated, they share the risk of clinical performance. How much risk is enough in consolidating, or rather in integrating financially or clinically? It's really not clear. Even since the Norman, Oklahoma advisory opinion, it's a little up in the air how much risk is enough. But let's look at what they were doing to achieve integration. Put in place procedures to oversee and control costs. That was a big point while maintaining quality of care, because it goes to the notion of lower prices. Using electronic platform to monitor participating physicians and their compliance with the standards set by the Norman PHO. That sort of that type of information was found to improve the quality of care, and thus the FTC deemed it a positive benefit. Participating practitioner agreement committing each physician to implement the Norman PHO's clinical practice guidelines. Same idea. Investments of time and money by the Norman PHO to realize efficiencies. They had a very minimal capital investment in that case. So that's what they pushed to the FTC. And they showed the need for joint contracting as well. You remember that the FTC is very skeptical about whether parties really do need to merge in order to achieve pro-competitive benefits. Here, this issue of joint contracting, the FTC was able to satisfy that broader concern about collaboration and the potential impact on competition. There would be a consistent panel of like-minded physicians with shared commitment to participating in all aspects of the clinical integration program for all patients under network contracts. And otherwise, they might vary from contract to contract, and that consistency was found to be a very important factor by the FTC. There was an incentive to participate in clinical integration projects which likewise would not be able to happen without this joint contracting. So the FTC looked at this. They found that it was not expected to affect the number of contracting alternatives because it was non-exclusive. And again, it was non-exclusive on paper. Going forward, the FTC would continue to consider whether in practice that was the case. The FTC was concerned that a substantial portion of physicians in the area would be in the network, but was able to overcome that because of a number of representations that the PHO made. First, that the consumers could bypass the PHO contract directly with providers. The network would not force payers to contract with the PHO, and it wouldn't use its monopoly power to limit competition in other areas. For instance, by requiring patients to use PHO physicians. It's perhaps a natural outcome of an agreement, but the PHO represented that it would not do that, and for at least at that time, the FTC was satisfied that that would be appropriate, and the PHO agreed to provide counseling on those issues to avoid that sort of thing happening going forward. Now, it's interesting because the Norman physicians represented the overwhelming number of physicians in the area, and it's an interesting hypothetical whether the FTC would have followed its same analysis, which seems difficult to distinguish if there had been 100% of physicians in the area. But analytically, that may be not distinguishable. But as a practical matter, it's a little difficult to imagine the FTC signing off on this collaboration that would essentially create a network of all the physicians in the area. So what can we take away from this? It's interesting that the FTC worked very quickly in this matter, and many points of this proposed integrated network were not even finalized when the advisory opinion was issued by the FTC. It's not clear if all steps that were taken in this case were necessary for approval. I think that's probably best practice if you want to do this, to make sure that all of these types of steps are taken, but it's not clear if all of them are necessary. The FTC, again, it left the door open to come back and sort of monitor the situation and see if, as a practical matter, there were going to be antitrust concerns with this transaction. While on paper it seemed like they were able to agree with what was going on, they wanted to see, at least have the option of seeing how it played out in real time. It was not linked to the Medicare Shared Savings Program. They still considered it. Integration doesn't eliminate antitrust risks, though, entirely, and the negotiations as they actually played out going forward, I think, are an example of that, because there still can be issues that arise moving forward. So how does an ACO minimize its risk? Non-exclusivity is the key. Don't prohibit carve-outs of services. By allowing that sort of non-exclusivity, it really does lower the antitrust risk and the concerns that the agencies might have. Now, transactions between competitors are typically called horizontal transactions, and they really do draw a lot of scrutiny from the agencies. The agencies also are tasked with considering the antitrust risks of vertical arrangements, and these are arrangements where, for instance, a supplier enters into an exclusive dealing arrangement with a provider. And so they don't necessarily compete. They're not providing the same products or services, but they're necessary to each other. And as you have vertical restraints on competition, those fall within the scope of the antitrust laws. but they haven't been a key focus for the agencies. If you look at the St. Luke's case, which we'll talk about in just a second, is a good example of that. In that case, a neighboring hospital participated in the lawsuit. It claimed that the transaction, which involved the St. Luke's acquiring Salter, which was an independent physician group, was a improper vertical restraint. And when the FTC came in and joined in this lawsuit, the FTC didn't follow that same vertical restraint theory, and instead used a horizontal restraint theory in that case, even though that's not what the initial complaint had alleged by the competitor. They're less of a concern because they're still typically an example, an opportunity to compete. And so those have not really fallen within the scope of the agencies as a practical matter. But let's talk about the St. Luke's case, because I think it's a pretty good example, and the Hershey case as well, I think dovetails very nicely with St. Luke's as far as the analysis goes. This involved the hospital St. Luke's acquiring Salter, which was an independent physician group. I will disclose that our firm was local counsel for St. Luke's in the litigation that was involved, but I did not work on the matter personally. The FTC alleged, though, that the acquisition included the right to negotiate health plan contracts and to establish rates and charges. While it alleged that, it's questionable if that was the case. But St. Alphonsus came in and alleged that this would give St. Luke's a dominant market share and allow St. Luke's to block referrals to St. Alphonsus. The trial court found that it did, in fact, threaten competition, ordered divestiture of the acquired physician group. This was a case where the FTC and the competitor came in after the fact, after this merger had been done, and asked the court to unscramble the eggs. The trial court said, yes, that's fine. We're going to do that. It was the first case that the FTC litigated through trial challenging physician acquisition, and the Ninth Circuit affirmed the trial court ruling. The relevant geographic market was the key, and we've talked about that. It really is where the FTC wins and loses its antitrust cases in the healthcare industry. If the FTC's vision of what that relevant geographic market is, it wins. And if the FTC loses that, it typically loses. So the court decided that it would not, for instance, allow continual monitoring in order to assure that itself that nothing anti-competitive was happening, and instead simply ordered the divestiture of the acquired physician group. Now, note the difference in focus, and this goes back to what I mentioned at the very beginning of this. St. Alphonsus is concerned about foreclosing competition, and competition is implicated by eliminating the incentive that the physician groups might have to refer patients outside the acquiring group, and so things would stay in St. Luke's, and that would impact competition. As a practical matter, it really would impact St. Alphonsus. The FTC noted that the acquisition gave St. Luke's the ability to extract higher rates from commercial payers, and so the FTC's analysis really was the hypothetical monopolist. It would allow St. Luke's to have a small but significant and non-transitory increase in its pricing, and by doing that, it was improperly creating a monopoly, and the transaction was inappropriate as a result. The Ninth Circuit agreed. What's the takeaway from this? One, the FTC is concerned about costs. That really is the primary driver of a lot of the FTC cases over the recent years. This really can be a problem if it is simplistically applied, because there can be benefits that, other than cost, that would warrant a particular transaction to be allowed. Improved quality of care, for instance, is a factor that really should be considered, And if the only concern of an agency or competitor viewing the transaction is the bottom line, some of the real benefits of these transactions might be lost. The FTC is concerned about reduced competition in the hospital services market, and this appears to be central to the FTC's enforcement analysis generally. We read the quote earlier from Chairwoman Ramirez expressing great concern, and this was just 4 months ago, about the danger of consolidation in the healthcare arena. And then finally, again, the geographic market, the relevant market, is critical to the antitrust analysis in a case. And so if you're considering a transaction, you need to keep that in mind, that what is the relevant market? Do we need to get an economist to come in and run this analysis so that we have a clear picture of what sort of market we're looking at and what kind of risk that potentially raises. Another point is what, and this is not in the slide, but a final takeaway from this case is, what do your documents say? What do your documents say about a transaction? What the FTC finds very frequently is that parties to a transaction early on will tout the benefits of a transaction, and only later, when they have engaged, for instance, antitrust counsel, will the benefits of the transaction start being things like, oh, we can be much more efficient, we can reduce costs and compete more effectively. If those benefits only show up later after antitrust counsel or an economist has been engaged, the FTC is much less likely to view those as being real reasons for the transaction. So it's important that those factors are considered as part of the rationale for a contract. And they may not be relevant, but they at least need to be considered. So, some conclusions and just general broad takeaways from antitrust and healthcare. The first is, and this is unfortunate, but there really aren't a lot of bright lines in antitrust law. What you find is that for the most part, when you get beyond naked horizontal agreements to fix prices, which are per se illegal, a lot of it really is simply a risk analysis. You can do things to increase the risk, and you can do things to decrease the risk. But without bright lines, that is the sort of analysis you have to be willing to work with on antitrust issues. Second, the agencies want to protect and encourage competition. Notwithstanding the legislative policy and the administration policy with respect to health care and the Affordable Care Act, the agencies view that as creating incentives that can reduce competition and thus harm consumers, and they are very, very watchful in the health care arena to make sure that doesn't happen. And finally, as a result of this, for the foreseeable future, the agencies are going to continue to focus on health care. The FTC in a presentation just a week ago mentioned again that healthcare is of primary importance to the agency, that it will continue to devote resources to it, and that it will continue to challenge what it views as inappropriate mergers and acquisitions in the healthcare arena. Thank you for participating today. If you do have questions, if you have comments or concerns, please feel free to submit those through the Events Center. Again, if you do have questions, go ahead and type those in, and we will respond so that all participants in the webinar today will be able to get those responses and be able to understand the question and the answer from that. So thank you for participating today. I hope you all have a good day.